Most likely, someone in a position of power colluded with the medical staff member and may have even discussed strategy with the Durham prosecutors. The following could have easily been the plan. 1. Give an oral contrast agent to induce vomiting. 2. On the reasonable pretext of protecting the airway, decide to intubate. 3. Place the endotracheal tube in the esophagus. 4. When the EtCO2 reading comes back negative, suggesting misplacement, use a laryngoscope to examine the tube placement and give false reassurances while leaving it in place. 5. By the time the heart goes into cardiac arrest due to lack of oxygen, the brain cells should be dead. And 6. Day dies, or if his heart is resuscitated, leave him on life support for a while and remove him from it, at which time he will die. Duke University Hospital then attempted to cover up the truth in Day's hospital summary record. It does this by switching events in the timeline, by placing cardiac arrest directly after the emesis episode and the initial intubation after the cardiac arrest. This arrangement precludes the intubation from being the cause of the arrest and suggests that it was due instead to aspiration following emesis. It accounts for the second intubation as being performed after Day was resuscitated, the reason for the reintubation due to a low oxygen reading. The Deputy Chief Medical Examiner, Dr. Clay Nichols, then produced a fraudulent April 14, 2011 autopsy report in which he fabricated injuries that did not occur to make the stab wound inflicted by Mangum appear much worse than it was. Dr. Nichols even described non-existent, quote, defensive stab wounds to the left upper extremity to suggest that he was fending off repeated stabs by his alleged attacker. Dr. Nichols then concluded in his report that the cause of Day's death was due to complications of a stab wound to the chest, omitting the esophageal intubation, cardiac arrest, comatose state, and elective removal from life support. With this bogus report as the foundation for the Durham prosecutor's murder charge against Mangum, Prosecutor Kelly Gallagher then trumped up a felony based on a little-known, rarely used larceny of chosen action charge. This charge hinged on Mangum being in possession of 2 cashier's checks, which Day, in an interview with police, stated he gave to her to hold until time to pay rent on the apartment. Note that both checks were filled out, with Mangum not being listed as payee nor remitter. Ergo, she could not have converted them to her benefit even if she so desired. Using the much maligned felony murder rule, Prosecutor Gallagher was able to classify the murder charge as first degree, a conviction which would hand Mangum a mandatory life sentence. The Monday following Day's death, April 18, 2011, the prosecution obtained 3 short-form indictments against Mangum, 1 for first-degree murder and 2 on counts of larceny of chosen action, 1 for each cashier's check. Short-form indictments consist of a few generalized sentences describing elements of a charge and are viewed unfavorably because they do not provide enough information upon which to allow the defendant's counsel to plan its legal defense strategy. Prosecutor Gallagher had reasonable belief that she could use the spurious charges to convict and sentence Mangum to life in prison without parole because of the following. 1. Reliance that the mainstream media would keep the truth from the people. 2. Belief that Mangum's defense attorneys would cooperate by putting forth a defense of show without substance. 3. Politicians lacking Naifongian courage and would therefore not touch the political hot potato. 4. The NAACP, ACLU, along with other civil rights organizations, would not stand up for Mangum's rights. And 5. The biased media has played a Jedi mind trick on Tarhelians with prejudicial pretrial coverage that painted her as a person who is a pathological liar, aggressively violent without provocation, is mentally unstable, and has a penchant for stabbing her boyfriends. At the heart of corruption in this case, and in other cases involving individuals connected with the Duke Lacrosse case, it is an unreasonable and malignant vindictive drive by powers that be to punish those whom they consider to be on the wrong end of the Duke Lacrosse case. Durham District Attorney Mike Nifong, Assistant DA Tracy Klein, Investigator Linwood Wilson, Lab Director Brian Meehan, and supporters of Nifong, including Sidney B. Harr. Particularly in their crosshairs is Crystal Mangum, the victim accuser who set off the entire civil and criminal legal brouhaha. Nearly a year prior to the stabbing incident, Durham police were dispatched to Mangum's apartment on a domestic violence call. According to police reports, they found some of her boyfriend's clothes in the bathtub that Mangum allegedly set ablaze. Instead of immediately dousing the flames by turning on the faucet or using a fire extinguisher from their cruiser, the policeman in charge simply closed the bathroom door and called the Durham Fire Department. This midnight action rousted 24 of Durham's bravest from their beds and brought them in approximately a half dozen vehicles to Mangum's apartment, which after 15 minutes of response time permitted the structure to sustain significant smoke damage. The reason for not intervening in the fire was an attempt to justify a criminal charge of felony arson, instead of the misdemeanor vandalism charge which it should have been. Several conscientious jurors prevented Mangum from being convicted of the serious felony charge, which carried a 7-year sentence, but a consensus for a guilty verdict was reached on a series of other misdemeanor charges, including injury to property, child endangerment, and the catch-all charge, interfering with a public official. The vitriol and contempt for Mangum is displayed by prosecution's desire to have her sentenced to life in prison without the possibility of parole, when in fact evidence strongly supports that she committed no crime and acted in self-defense when she stabbed an intoxicated Reginald Day. The possibility of placing Mangum behind bars for life was very tempting, and it was within reach if Day did not survive his hospitalization. Motive, means, and opportunity were within the walls of Duke University Hospital. An investigation to rule out a possible hospital homicide should have been conducted immediately, based on the following fact alone. Esophageal intubation leading to brain death is extremely rare. In addition, safeguards to detect and correct the lethal tube placement, such as the EtCO2 monitor and visual observation with the laryngoscope, were fruitless. A minimal investigation should include the number of such similar incidents in Duke University Hospital's past and a background check to the person responsible for the intubation and evaluation of the tube placement. For example, was the individual a Duke graduate, a former Duke lacrosse athlete or fan, a rabid racist? Did the person's financial account receive a sudden and unexplained infusion of cash, and or did he or she unexpectedly benefit professionally or personally subsequent to the incident? I cannot say with complete certainty that Reginald Day's death was a result of homicide at the hands of staff at Duke University Hospital, but I can say without doubt that he definitely did not die by Crystal Mangum's hand. Before you, the case is made to support the probability that Day's death was not accidental and was in fact intentional. My inclination is that Day's life was willfully sacrificed in order to saddle Mangum with a first-degree murder charge in hopes of winning a conviction for a life sentence. The truth is moot, as authorities will not conduct an objective and unbiased investigation in good faith. Whether Day's death resulted from accidental medical malpractice or was the end result of a sinister plot is left up to you individually to decide. In deciding, ask yourself this question: what would Lieutenant Colombo think and do? As regards this point, I believe the lieutenant and I are on the same page.